Well, the clock is ticking for the former president to hand himself over to authorities. Zuma has until tomorrow to do so, or he faces arrest. But the former head of state is not going down without a fight, it seems. On Friday, he filed an urgent application to have his 15-month sentence rescinded. So can he really actually avoid spending any time in jail? And what other legal options does he have? Let's unpack it now with legal expert Ulrich Roux. Ulrich, good afternoon, and thanks for your time this Saturday afternoon. And I'm not sure if you got to hear what Paul Hoffman actually said, saying that Zuma's defiance of the highest court in the land has actually come to an end. Do you agree with that, or do you think that the former president does still have some tricks he can use?
Hi, good afternoon, Vivek, and thank you for having me. Yes, I could hear what Paul Hoffman had to say, and I agree with him wholeheartedly. You know, this is we've come to hate this word so much during the past 2 years, but this is certainly an unprecedented application by Mr. Zuma. He's brought two applications. The one is an application before the High Court in Pietermaritzburg, in which he claims that the High Court must stay the execution of the order handed down by the Constitutional Court, pending his rescission application to the Constitutional Court. So, firstly, the application to the High Court, in my opinion, has absolutely no chances of success, and there's no merits for him to bring the application. As we all know, the Constitutional Court is the highest court in our country, and any order made by the High Court is not binding on the Constitutional Court. So if I had to predict what was to happen with that application, I would say that it's going to be rejected from the outset. And then, as Paul Hoffman correctly pointed out, you know, the only chances of a rescission application succeeding is if he can prove, in terms of Section 29 of the Constitution, read with Section 42 of the Uniform Rules of Court, that a grave error was made in the court reaching the conclusion that it reached. Now, this is the Constitutional Court. It is the highest court in our country. The 11 judges sitting in the Constitutional Court is regarded as the top 11 judges in our country. They deliberated over this application for a period of 3 months. They handed down a very detailed and very complicated order after having considered all of the possible legal outcomes that they had to consider. And this is the conclusion that they have reached. Now Mr. Zuma is going back to this very same court, to these very same judges, and saying that you made an error. You must reconsider this order that you made. I simply cannot see it being successful. And as you correctly pointed out, the clock is ticking. The order handed down gave Mr. Zuma 5 calendar days, and clearly pointed out that it is calendar days and not court days within which to hand himself over. Those 5 days expire tomorrow. So if he does not hand himself over to the South African Police Services tomorrow, then the police commissioner and the minister of police have been ordered, in terms of the same Constitutional Court order, to use whatever means possible to arrest him and to incarcerate him for him to start serving out his sentence. So the time is running out for him. I also have no idea whether the Constitutional Court will even entertain this application. The Constitutional Court does not sit over weekends, and the application was filed yesterday. So if one had to adhere strictly to the order, then if he does not hand himself over tomorrow, then he should be arrested.
So just looking at it then, Ulrich, he has completely run out of possible reasons, plausible reasons for why he shouldn't actually go to jail. I mean, he also, you know, kind of failed to defend himself before the Constitutional Court and to appear before the Commission, saying while he was under summons. And he now saying that he always wanted to appear before the Commission, but the dates coincided with things like medical examinations. He didn't leave deliberately. He was, you know, there was a mistake made. He was going to, needed to take medication. And you have to wonder, you know, does he really think South Africans and our judicial system are that stupid?
Yes, that's putting it bluntly, Vivek. I think his application, and I've read both applications, is completely disingenuous. He's saying that the Constitutional Court made an error in law in not affording him an opportunity to address the court in mitigation of his sentence, should he be found to be in contempt. But that is factually incorrect in its entirety. In April, he was given an opportunity by the court to address the court should the court find him guilty of contempt. And he elected not to do so, as has now been ventilated extensively. He rather elected to pen a letter to the outgoing Chief Justice Mogoeng, in which he made it clear how disappointed he was at the Constitutional Court, how he likened the Constitutional Court to the apartheid regime, how the Constitutional Court and the judges clearly had a personal vendetta against him. Absolute nonsense. He should have just answered the application before him. And if he had done so, he would have purged his contempt. If he had elected to go and testify at the commission, then this application would never have been brought. So you correctly point out that, for a man who, for the last 10 years, he has consistently said that he wants his day in court so that he can clear his name. He was given that opportunity by the commission. Upon arriving at the commission, he then refused to testify because he claimed that it was unconstitutional for him to do so because Justice Zondo was clearly biased and that he had to recuse himself. All of the legal avenues were followed. An application for recusal was brought, it was dismissed. An application to review that decision was brought, it was dismissed. Then the commission had no choice but to approach the Constitutional Court, which it did. And Zuma then had an opportunity to defend himself in that application again, which he refused to do. So I cannot now see that, as you correctly point out, the defense that he has now raised, one, is that he is suffering from severe medical issues. And as a result of him having to take his medication, he could not attend to the commission on the one day for a hearing. And that then put into motion all of the next steps that followed. And secondly, he's now pleading poverty as well and saying that he cannot afford to litigate on all the fronts that he is now being involved with in the numerous court cases, and that he elected because of financial decisions not to oppose the Constitutional Court application, which, no one has to tell you that that is a very bad decision to make from the outset, because this is the highest court in our country. If you had to choose which matter to oppose and spend legal fees on, then surely the Constitutional Court matter should be that. So, I just think that he has reached the end of the line, and unfortunately for him, all of these defenses are going to be dismissed.
So, Ulrich, it's clear, either hand yourself over or be arrested. And just explain to us, because there's lots of legal opinion out there, also on social media as well, saying that if he does hand himself in, there will be some leniency. He might just spend, maybe just a few months off those 15. And if he's arrested, then will he have to go the whole hog, or does he go to, the hospital section of the prison? Where he might get better treatment. What are the scenarios that could play out there, depending on whether he hands himself over or he is actually arrested?
Look, on the medical front, even though he would be arrested and serving his sentence, he's still entitled, obviously, to medical assistance in terms of our Constitution. And if his medical condition is of such a nature that he needs to be taken up in the medical wing of a prison, then so be it. He will still be in custody and he will still be serving his sentence. Whether he hands himself over or not at this stage will definitely not contribute towards him serving a shorter sentence or not. The Constitutional Court order was very clear that it is an unsuspended sentence for 15 months imprisonment. The only department who can adjudicate whether he should be released early is the Department of Correctional Services, and they take into account all of the rules pertaining to a person's release on parole whilst serving their sentence. This could possibly be seen as an aggravating circumstance if he does not hand himself over, but that would only be adjudicated upon much later if it is a person who qualifies to bring an application to be released on parole or not. I think what the legal commentary is referring to on social media is if a warrant of arrest is issued for a person and he's arrested, he would then be granted an opportunity to apply for bail. If he handed himself over and he willingly cooperated with the authorities, then that obviously is seen as a mitigating circumstance and could contribute towards swaying a magistrate to release him on bail or not. This is not the case with Mr. Zuma. He's being arrested to start serving a sentence. He is not going to have any bail application. So whether he hands himself over or not is not going to count in his favor now. It could possibly have a small bearing on a parole application later on. But yes, I cannot see that he would receive any other advice other than to hand yourself over. If you believe that there are legal grounds for these applications, they could be heard without you being present and whilst you start serving out your sentence. But But surely to now try and defy a constitutional court order once again and basically challenging the Minister of Police and the Police Commissioner to use any means possible to arrest you would not be the right strategy and way to go about this. And this other claims by the Mkhonto Wesizwe veterans, where they are claiming that they will use whatever means possible to avoid him being arrested and they will resort to violence. It is utter nonsense. We live in a society and a country that is governed by laws and rules. We cannot resort to complete lawlessness and barbaric actions whereby a group is now going to prohibit the police from carrying out their duties, and those duties which are in line with a constitutional court order handed down. So one can only hope that sanity will prevail and that Mr. Zuma will hand himself over in accordance with the order. Start serving your sentence. If you believe that there's any legal grounds for the sentence and the order to be set aside, then that could be argued whilst you're serving your sentence.